All right, let's go ahead and get started. Thank you everyone for being with us this afternoon. We really appreciate your participating in our overview of Massachusetts workers' compensation webinar. My name is Jamie Spiller Kaplan. I am a partner here at Chartwell Law, and I head up our New England workers' compensation practice. Today, this presentation is going to be led by my colleague, Tom Richard, who is an expert on all things Massachusetts. I am going to turn this over to Tom. If you have any questions as we move along on this webinar, if I could ask you to please put them into the Q&A box at the bottom of your screen. That would be helpful if you could put your questions there rather than the chat box or raising your hand. I will be more or less serving as your chat bot this afternoon and do my best to respond to all of your questions in real time. So with that being said, I am going to turn this over to Tom. And again, on behalf of Chartwell Law, thank you so much for joining us.
Welcome, everyone. We appreciate you being here today. I do see a lot of names I know that have joined us. Welcome to all those new faces as well. We hope you can take something from this presentation. Before we start, I do just want to let everyone know that this webinar is recorded. So if afterwards you would like a copy of it, please reach out to Jamie or I. The PowerPoint presentation will be available as well, so you don't have to sit there and take notes hastily today. So without further ado, I'm going to jump in. We're going to run about an hour. We might have a few minutes left at the end for questions in the chat box live, but as Jamie said, she will be answering those as we go. So let's start. So the Massachusetts workers' compensation law, whether you're a new adjuster, have been doing this for a while, especially those of you who handle many jurisdictions, you may not know exactly where the Mass Work Comp law comes from. So we have a few different sources. The first is the actual statute, which is Mass General Law, Chapter 152. The link is there for you. You don't need to click that now, obviously, but parts of the statute are referred to as sections. So for those of you who are familiar with Section 34 benefits, Section 34A, and Section 35. When people are saying section, they're referring to that part of the Massachusetts Work Comp statute. Section 34 is temporary total disability, 34A permanent total, and 35 temporary partial. So those are the most common forms as an adjuster of the benefits that you'll see. Aside from the Mass Work Comp statute, there are the regulations. Again, the link is there for you. This is 452 CMR 1.0 through 9.00. Regulations differ from the statute. They're more precise. They go into more detail. They pertain to things such as form filing. When do you need to get the form out? How do you do it? That such of information. And lastly, we have our case law. So you have the Massachusetts Supreme Judicial Court, which is the highest court in the state. You have the appeals court, and you have the reviewing board. Going backwards, the reviewing board is the highest workers' compensation court. It is an appeals court, and that would take place after a hearing, which we'll talk about a little bit more later on. We also have the appeals court. So if something does get appealed from the reviewing board, that actually goes into the state court system, and then again up to the SJC if it gets appealed from there. Very rare that things get appealed even past the reviewing board, but does happen. So part of the Massachusetts Workers' Compensation statute does include a definition section. A frequent question we get from new adjusters or even seasoned adjusters or employers or insurers, what does this mean? So these are some of the common definitions that you'll see that you might need information on, such as average weekly wage. How do you calculate it? It's right in the statute. What counts as a dependent, and what's the definition of an employee, an employer, an insured or insurer. I won't get into too much detail, but these things, again, if you follow the link on the prior slide, the definitions are there for you. Same thing with the code, which we talked about as well. There are definitions on there that are useful to you as an adjuster. Filed, what does that mean? Is it when I submit something online? Is it when I place it in the mail? That's all covered there. Interest, how much, how do I compute it? Same thing. And necessary expenses, which is actually important. I'll talk about that briefly. when you get hit with a conference order or hearing decision, oftentimes you're ordered to pay for the employee's attorney's expenses. Some plaintiffs' counsels have been known to sneak in certain things that aren't owed, such as parking or gas. So necessary expenses will tell you what you do owe out of that. So it's a useful tool to have some of these definitions in your arsenal. One of those definitions that actually I will go into in depth is personal injury. Obviously, only personal injuries are compensable in the Massachusetts Workers' Compensation Law, so it's important to know what constitutes a personal injury. So Section 1, again, is the definition section, but 7A is the part that includes what a personal injury is. So personal injury shall include, and this is really relevant right now actually, infectious or contagious diseases if the nature of the employment is such that the hazard of contracting such diseases by an employee is, and this is the key, inherent in the employment. So right now, obviously, we're in the middle of a pandemic. We have COVID-19 out there. Probable cases where a COVID-19 diagnosis would be compensable. If you're a lab tech and you're studying the disease, under a microscope and you're working with it every day, that's probably compensable because that would be inherent in the employment. Likewise, if you're a doctor or a nurse in a hospital and your patients are all infected with COVID, you're on a COVID wing, that's probably compensable as well. Conversely, if you're a bank teller, a cashier, a limo driver, where your risk is the same as pretty much everyone else in the workforce, that's probably not going to be compensable. There's a little gray, obviously, because this is a new disease infecting everyone right now. So there's legislation currently pending addressing whether or not first responders, police, firefighters, EMTs will be covered. So right now that's possibly, but as the case law continues to evolve, we will provide updates if anything is passed. But for now, that is sort of gray. So that's a case by case basis there. Personal injury shall also include mental and emotional disabilities, but only when the main contributing cause of such disability is an event or series of events occurring within any employment. So you have your physical injuries and you have your mental injuries. For a mental injury to be deemed compensable, it's a higher standard than the physical injury. So for example, if you have 10 mental health issues that you're seeing a mental health professional for, and 9 of them contribute, let's say 10% of the reason why you're being there. As long as the industrial accident contributes 11% towards your need for treatment or disability, then it would be compensable. It doesn't have to be 99% or 51%, it just has to be the leading cause. Going on though, a personal injury shall not include mental or emotional disabilities arising out of a bona fide personal action. So that's someone gets fired, promoted, demoted, if their job gets transferred. Usually those are not compensable if they allege that they have a mental or emotional disability. However, if there was some sort of intentional act intended to cause harm by an employer, that would be the one exception where those injuries would be compensable under the statute. And lastly, a personal injury shall not include any injury resulting from an employee's purely voluntary participation in any recreational activity. So company picnic, company basketball team, anything like that. Even if you're going out to dinner and the employer is picking up the cost of it, if it's purely voluntary, that's not going to be covered. There's actually one more part of the personal injury definition that merits some additional information. So personal injury shall include a compensable injury or disease that combines with a pre-existing condition. So anything that's not compensable, whether it was a prior disease or an injury, that causes or prolongs disability or a need for treatment, only to the extent such compensable injury or disease remains a major, but not necessarily predominant cause of disability or a need for treatment. So if you're an adjuster and you're aware that your claimant has some prior issues going on, whether they're prior surgeries or prior diseases, and you suspect that your claimant has been treating for a while and they're back to their baseline, you'll see that 1.7a is often checked off in the other section of the denial forms or on a form to terminate benefits during the pay without prejudice period, which we'll touch on a little bit later. So it's a good tool to have in your repertoire, but it does, excuse me, a little quick. Actually, something didn't carry through from the slide, but that's okay. So this does differ from the subsequent insurer rule. So basically, if you have a prior condition and it's aggravated or exacerbated by a work injury, you do all those benefits until that person gets back to baseline. But if you have a series of work incidents, so it differs from non-compensable injuries. So if you have a series of injuries that occurred at work all throughout, and then you have your claim that is going to be compensable, even if you only aggravated those prior work-related injuries by 1%. So the last insurer on the risk does own that claim. There's no apportionment in Massachusetts. So insurer 1 doesn't pay 20% of ongoing disability or the need for treatment. Insurer 2 doesn't pay, 40%. Whoever the last insurer on the risk would pay the whole claim, even if arguably the first, few work-related injuries contribute to the current need for treatment.
So just to chime in, we often think about this rule in Massachusetts as being last on the risk, and that's a good way to think about whether or not you own compensability, or in an ideal world, if you can pass compensability off to someone else.
You often see this a lot in asbestosis claims, where you can't tell necessarily where someone caught that disease. So the last insurer on the risk usually ends up owning the claim, and the other insurers usually contribute if that claim is eventually settled. So that's personal injury. I do want to talk a little bit about forms, which are very important. Especially in Massachusetts, and especially for adjusters, which I imagine most of the people watching this are. So the first form that you'll see most likely is the Form 101. That's the employer's first report of injury. Sometimes the form says death or illness as well. Why do you need to file a Form 101? Only, so you don't need to do these for non-medical injuries, medical-only claims, but any injury alleged, so even if you're not going to pay for the claim, you still need to file the form. So any injury alleged to have arisen out of and in the course of employment which incapacitates an employee for a period of 5 or more calendar days. So it doesn't matter if this person was scheduled to work or not. After the 5th calendar day and they're still out of work, you need to file that form. How do you file the form? So pre-COVID, you could submit that through the mail, but now things have changed. The Department of Industrial Accidents, which I'll refer to as the DIA from here on out, does have a claim management system. If you do not already have a login, you can go to their website and obtain one. But they do have a portal that you fill this form out through, as well as most of the other forms that we'll talk about shortly. So how long do you have to file this form? So on that 5th day that triggers when you need to file the form, you have 7 days from there. So really 12 days from the date of injury. Who's going to file this form? This is the employer. However, if you are a TPA, that is part of your role. You need to file that, especially again, when you have notice, if it's not within those 5 days, you need to make sure you're getting that done quickly. What happens when you don't file this form? So if you do not file it, and this is your 3rd offense, you're going to be hit with a $100 fine. And then each time after that, it's a $100 fine. And also, if you don't pay the fine within 30 days, it's another $100. So it is important. It may seem like a nominal amount of money, but I'm sure those add up, and clients won't appreciate being hit with $100 fines. So the next form that we'll talk about is the 110. That's an employee's claim. So as an adjuster, you're never going to file this out, but you are more likely than not going to see this come across your desk, either by email, fax, or mail. Typically, you see these after a claim is denied or after benefits are terminated. We'll talk about that in a little bit shortly as well. But attached to the employee's claim most likely will be some sort of medical documentation or some non-medical evidence supporting the claim. There's also the Form 103. As an adjuster, this form is fairly important. What is it? It's the insurer's notification of payment. And why do you file it? So when you receive a Form 101 or a Form 110, and you're aware that the claimant is out of work for 5 days, you do have to decide whether or not you're going to pay this person. Excuse me. So there is a 5-day waiting period in Massachusetts. The claimant isn't owed compensation unless they're out longer than 21 days. So later on, you would owe those first 5 days if they remain out. But at the start, you do have to make a decision whether you're going to accept the claim or pay without prejudice. And I'll get into the pay without prejudice period a little bit later on today. Again, this form is filled out through the DIA website, and you have 14 days. So if you receive a Form 101 and it indicates that the claimant hasn't returned to work and it's been 5 days, or if you receive that 110 alleging that weekly compensation is already, whenever you receive it, so now when it's placed in the mail, whenever you get it as an insurer, an adjuster, or a TPA, that's when that 14 days starts. After you make that decision, you have 30 days to file the 103 with the DIA. So the issuing the payment is the more important aspect of answering 110 or 101. So again, the adjuster or the insurer, the TPA, is responsible for filing this form. Notably, interest, if you do not file the 103 and you are later ordered to pay weekly compensation in either a conference or a hearing, you may be required to pay interest at a rate of 10%. Likewise, if you fail to issue a 103 and commence payment within those 14 days, you do owe $200 to the employee. The penalties get significantly steeper after that. After 60 days, $2,000 to the DIA. Then at 90 days, you might owe $10,000 to the DIA. So it's really important when you receive the 101 or the 110 to not only issue payment, but also to file that 103 to indicate to the DIA that you have issued payment 1 and whether or not the claim's accepted or paid without prejudice. Alternatively, if you do not want to pay weekly compensation, you don't have enough evidence from the claimant to support what they're alleging, or there's something else suspicious about the claim, you could deny it. And you would do that by filing the Form 104, which is the insurer's notification of denial. Again, this is in response to the 101 or the 110, whatever you receive for first. And you do file it, again, electronically. There are other requirements aside from filing these forms electronically. With the 104, you do need to send a certified copy through the mail to the claimant, as well as issue a copy to the claimant's attorney if they have one. Again, the same timer applies. 14 days of receipt of the 101 or the 110. If you're not going to pay the claim, the 104 needs to go out. Excuse me. Again, there's also interest and penalties similar to the 103 if you fail to do this within those 14 days. So what's the difference between, or the advantage rather, of filing a 103 versus a 104? So if you do file the 103, commence payment, what you do is you preserve the payment without prejudice period, also known as the PWAP. For those of you who don't know, an insurer that makes timely payments, and again, timely payments is within 14 days of receiving the 101 or the 110, you get 180 calendar days from when the person's first disabled to continue paying the claim on a payment without prejudice basis, meaning that you can contest any issue later on. So if you're not sure whether or not something's compensable, maybe you don't have the right medical evidence at that time, you don't think the claim's worth denying it, but you're not going to accept it, you could file the 103 and indicate that you're paying without prejudice, which does reserve all your rights. You're not accepting the claim. You can change your mind at any point in those 180 days.
If I can jump in really quickly, you can really only change your mind within 173 days because you have to give 7 days notice before terminating somebody's benefits during the pay without prejudice period. So even though we think about that whole period as 180 days, we try and encourage people to think about 173 days, because that 173rd day is your last opportunity to give notice before you have inadvertently accepted the claim.
All right, that's a good point, Jamie. And expanding on that a little bit too, you really don't want to even wait the 173 days, especially if you're going to plan on terminating benefits due to medical reasons and you want to schedule an IME, an independent medical examination. You really want to set a diary, maybe 2 months, give yourself enough time before the pay without prejudice period expires so you can act on that, because you can't really do it without valid reasoning. And again, you do need the 7 days written notice, unless, of course, the person returns to work, which is a different issue. Notably, though, you can extend the payment without prejudice period once, and you can do that by executing a Form 105. So the Form 105 is an agreement to extend the payment without prejudice period. It does need to be signed by the claimant or the claimant's attorney. So oftentimes they refuse to do that. So if you don't have that IME, you can run into an issue where the claimant's unwilling to extend the payment without prejudice period, and you're stuck paying benefits past that. And now you have to look for alternative methods of discontinuing their compensation. So if you do file the Form 104 instead of the 103, you don't get the PWIP. The PWAP period is waived. So it's an issue because if you do, after you file that denial, issue a payment, whether it's medical or weekly compensation, you got to be careful because it could result in acceptance of the claim legally. If you're paying just one medical bill for a body part that you didn't want to cover, now you own that body part. So again, too, after you file a denial, if you change your mind, if you receive additional documentation supporting the claim, or if you learn something about the facts of the injury that sways your opinion, it's much harder to legally discontinue benefits after you've issued a denial. So usually it's recommended that you do pay the claim without prejudice if you're not sure. And again, within those 173 really days, you can make that decision later. Also, if you do file a 104, you're opening yourself up to interest if you're later ordered to pay compensation. And more often than not, and Jamie will tell you that if you do deny a claim straight up, usually a 110 will be in the mail within a couple of weeks. And
yes, that's very correct.
Segueing into litigation, for those of you who don't know, there are a few different stages at the DIA. Which is an administrative court at the Commonwealth. So there are different rules that apply there than in different courts. So stage one is the conciliation. So what this is it's a very informal proceeding where usually the attorneys from the claimant side, as well as from the insurer or the self-insurer side, will meet with a person known as a conciliator to discuss what's going on in the claim. So if, for example, a Form 110 is filed, automatically a conciliation will be scheduled even before the insurers had a chance to either pay it or deny it. So if once a 110 is filed, if you as an adjuster already pay that, the conciliation will just be withdrawn. But if there's still a dispute, this is where both sides discuss what they're looking for. At that time, they may supplement any initial documentation that was attached to the 110. So you might get newer or updated medical records that weren't available the first time. So basically, the conciliator acts as a gateway into the litigation world of workers' compensation. So after the conciliation, usually the claimant does not participate in that proceeding. A few things could happen. The conciliator could hold on to the matter, one, because they're not in receipt of certain key information or certain wording that they're looking for, or two, because they're going to give the parties enough time to either work on resolving the matter or even potentially settling the matter. But if the parties express that they have no interest in exploring resolution or settlement, and the medical and non-medical evidence supports either the claim or the insurer's discontinuance, which we'll talk about a little bit later, it will be sent forward to what's known as a conference. So the conference, depending on which court you're in, there's 5 courts in Massachusetts. There's one in Springfield, there's one in Worcester, there's one in Boston, there's one in Fall River, and there's one in Lawrence. So depending on which area you're in, the timeline from conciliation to conference greatly varies. Obviously, with COVID, there are significant delays in the court system right now. As a result of that, I do know that Lawrence is pretty caught up. So maybe 6 weeks is probably average for that. But before COVID, it could take up to 3 to 4 months sometimes, depending on volume. So it does greatly vary, which is sometimes beneficial because it does give you additional time after the conciliation to potentially resolve the matter or to obtain evidence that you'll need ahead of the conference. So what is the conference? The conference, again, it's an informal proceeding. However, this time, instead of a conciliator, you'll be in front of a judge. Normally, this is in court, but right now these are being conducted virtually due to COVID. The employee or the claimant is required to attend the conference under most circumstances. Again, with COVID, there are exceptions. So they're not always present, but they're required to be in most circumstances. So at the conference, depending again, if it's an employee's claim or an insurer's discontinuance, both sides will present their case explaining why either benefits should be paid or why they should be discontinued or modified. So in the case of an employee's claim, they will present, the attorney for the employee will present their argument. They will also submit medical and non-medical exhibits. Likewise, the insurer's attorney will submit medical and non-medical exhibits, as well as make an argument as to why benefits should not be awarded. After the conference, the judge, going back, the judge will ask questions of the attorneys and sometimes the claimant, but this isn't a case where you'll have any testimony. Again, it's a very informal proceeding, mostly an oral argument, but the judge will chime in every now and then. So after the conference.
Can I just jump in for 1 second?
Yep.
Just to highlight a few things about the conference that you folks should really be aware of. Even though it is an informal proceeding, like Tom said, when the DIA assigns a judge, unless the judge retires or leaves the bench, that's your judge for the life of the case. So it is a very important proceeding because it's your first opportunity to present your evidence to the fact finder, and that fact finder will remain the fact finder throughout the life of the case. That's even the case if there are issues that are litigated 10 years down the road, if that judge is still on the bench. So the conference is a very key proceeding in terms of setting up the case and your first opportunity to present it to the decision maker who will live with this case for its life.
Thanks, Yumi. So yeah, after the conference, the judge will issue their conference order. Conference orders range greatly. A judge could deny an employee's claim. A judge could order the insurer to pay the whole claim, or there could be some decision that's split down the middle. So as most of you know who handle Massachusetts workers' comp frequently, Massachusetts is a very employee-friendly state. So more often than not, unless there's really, really, really persuasive evidence to deny a claim, those are few and far between at the conference. If there is a matter where an insurer has an IME and the employee has an opinion from their treating physician or another independent medical physician, more often than not, the administrative judge will adopt the opinion of the employee's medical professional, which again will result in an order of benefits. The work comp statute in Massachusetts was created to protect the employee, not the insurers or the employers. So again, it is difficult without very persuasive evidence to secure a victory at conference, but that doesn't mean you shouldn't show up and present your case, especially if you have compelling evidence. So after the judge does issue their conference order, usually it doesn't end there. One side is most likely not happy with how things turned out and they will appeal. You have 14 days from the date the conference order is issued to file an appeal. If there's a medical dispute, with the appeal, you also owe a $650 fee. And what that goes to is the impartial physician who will perform an examination sometime in the near future after the conference. So again, the time frame here varies on case to case and whether or not we're in a pandemic, but it could take as many as 3 months to get an impartial physician examiner even assigned to a case. So in advance of the impartial examination, there's a few things you can do aside from either adjusting the case or settling. If you were lacking medical information at the conference, now's your last chance really to go back and get that, whether it's by subpoena or by request for production of documents from the other attorney, from the claimant's attorney. You have 14 days from the date of the impartial examination to supplement your file. So you really don't want to wait that long. As soon as you have any additional medical evidence or non-medical evidence, even after the conference, you want to submit that as soon as possible so the impartial physician can review that. So with the impartial examination, what this entails is the DAA, not the insurer, not the employee, the DAA picks a doctor from their list of approved physicians, and the employee is sent to them for a completely independent review. The doctor does, as I just described, review all exhibits that were submitted at the conference. They will do a physical exam. They will talk to the claimant about any ongoing complaints, about the history and the like, and they will prepare a report. That report must include certain things. It must include whether or not there's a disability, whether or not that disability is ongoing, and whether or not that disability is related to the alleged industrial accident. The doctors should also comment as to whether a medical end result has been reached. If there is any loss of function or permanent damage, they would also comment on that. If the impartial physician does not comment on any of those items that are pertinent in whatever the specific case calls for, the impartial report could be found inadequate, which simply means that instead of being the only medical evidence looked at the hearing, which is the next phase of litigation, the parties will be able to submit their own medical opinions. But in most circumstances, the impartial report is adequate. The doctors comment on everything they're required to, and that report is the only piece of evidence that the judge will look at the hearing. So oftentimes the impartial report determines whether or not, at least from a medical standpoint, you're going to be successful at the hearing. So oftentimes an adjuster or insurer and employer, they'll want to wait until the impartial exam to kind of get a sense of where things are going before they make a decision with respect to settling or proceeding forward to the hearing or withdrawing.
And just to chime in, to be clear, it is the only medical evidence that would be allowed to be presented. Certainly factual evidence can be presented from both parties at a hearing, even if an 11A examination is found to be adequate, just to be clear.
Thank you. Also with the impartial examination, after the hearing, you are allowed to take the deposition of the physician who prepared that report. So if something's not clear, or if between the impartial exam and the deposition date, something else happened, you can bring that to the impartial physician's attention, and maybe they'll change their opinion or supplement their opinion based on the new information too. So that is another tool at your disposal.
I just jumping in really quickly. When you said deposition, I thought this might be a good place to just add, because we get this question a lot about whether or not depositions can take place prior to the litigation going forward. And a very weird feature of the Massachusetts system is after the 11A exam is really the only opportunity for depositions, and depositions, even when an exam is opened by the court, are limited to medical experts, be it your expert, the employee's treating physician, or the 11A doctor. But we get this question a lot. Can we depose the employee? Can we take depositions right away? And unfortunately, and kind of maddeningly in Massachusetts, it's not an option until this sort of late phase of the litigation. So I just point that out for educational purposes.
Likewise, you can also not send interrogatories or lists of written questions to claimants. That's not a thing we do in Massachusetts workers' comp. We also get that question quite frequently. However, as I mentioned earlier, you can request certain documents, which is usually limited to medical records or employment records or the like. If there is a dispute, obviously, that could be an issue that goes before a judge as to whether or not something should be produced. So when in doubt, you can always request it and proceed from there if you're not sure whether or not you're entitled to that or not. So after the impartial exam, the next step is sort of new. It is a product of COVID, but it's a pre-hearing conference. So the DA has changed a few things, which is actually beneficial because it does make the whole process more efficient. Normally, as Jamie will attest, on your first scheduled hearing day, you'll show up and it'll really just turn into a status conference anyways. Most cases don't go forward on that first day, if at all. So the DI has introduced this pre-hearing conference, which at this time, again, they're being conducted virtually. The employees have not been participating. It's just the judge and the two attorneys. It is slightly informal, but in advance of it, you are required to complete a joint pre-hearing memorandum, which essentially outlines all the issues on both sides, what benefits are being sought, what benefits are being requested to be discontinued. Are there any legal issues? Are there any motions? The like. So it is a good idea to have this proceeding. It actually does make things in the end run much smoother. But this usually takes place after has to take place after the impartial examination. Once both sides have had a chance to really review the medical evidence, see what the rest of the non-medical evidence stands at that point. And it really allows both sides one more opportunity to see if they can resolve the matter, or if they're going to withdraw, or if they're going to proceed forward to the hearing.
If I can just add one little piece about that, what has been nice about that in practice is the insurer's attorney, employer's attorney, so us, we tend to be the ones initiating the completion of that report. And it's a great opportunity for us to frame the issues in a light that is favorable to us. Certainly both parties need to sign off, but nonetheless, it provides us one more opportunity to present our case in a favorable light to the court.
Mm-hmm. Yeah, it's a good point, Jamie. In my experience so far, I've been pretty much throwing those out ahead of time. And like you said, you get to kind of shape the issues to how you see fit. And there's definitely advantages to that. So lastly, we do have the hearing. So the hearing, not quite what you see on TV, but it is a formal proceeding. You have a judge. You have a stenographer who's going to, dictate everything that's said. It's also recorded, and you do have the employee there as well as any witnesses. Right now with COVID, hearings that they do go forward are sometimes being broken into multiple days, especially if there's multiple witnesses, just in the interest of not having too many people together in one room at a time. So at the hearing, both sides pretty much have all their evidence gathered. Both sides know what the other side has, and it's a formal proceeding where the employee will testify as to the industrial accident, their current disability. After they testify, the insurer's attorney has the opportunity to cross-examine them. So hearings, again, depending on the exact issues, could take one day, they could take a couple of days. I've had a 5-day hearing that was expanded throughout 6 months. There are a lot of witnesses involved and the issues were very complex, so that's why it took so long to get done. But after the hearing, whenever it's done, you do have a phase where the judge will allow both sides to submit medical and non-medical evidence, again, only medical if the record's been opened because there's an issue with the impartial report or because the judge finds that the medical issues are complex. Complexity, what that really means is it's very subjective and it's up to the judge. So if you have a claimant and they're alleging 20 different orthopedic injuries, most likely the judge is going to open the record because he's going to want to see medical evidence from different experts pertaining to each body part. Similarly, if you have a head injury with multiple brain surgeries, the judge is certainly going to find that complex. Or if you have an instance where someone's alleging personal injuries as well as mental or emotional injuries, more likely than not, the record's going to be opened. That doesn't mean, again, that the impartial physician's report is going to be thrown out. Most of the times that report's not struck from the record, so the judge could still come back and adopt part of the impartial report or all of it, and they could also supplement their findings with the other medical opinions that each side submits. So again, the judge, after the hearing and the trial is done, you'll have that window to submit the additional records, as well as to take the deposition of the physician. And then both sides also have the chance to prepare a brief, which is essentially everything you got, you throw in this brief and make your case. You can attach exhibits to it, but it's really your last written argument explaining why you should prevail at the hearing. And after the hearing, the judge will take, varies, I guess, really, depending on the judge and how busy they are in their backload of cases. I've had a hearing decision within 30 days, which is what technically is supposed to happen, but that's few and far between. I've waited as long as a year for a hearing decision on what I thought to be a simple case. So it does greatly vary. It also depends, again, on the volume of cases that the judges have. Each judge does have writing weeks where they don't have any proceedings, so it gives them time to work on their caseload. But again, they start, first in, first out. So depending on where you are on that queue, it might take a long time. And unfortunately, if you're an insurer and you are paying benefits pursuant to a conference order, you are going to continue paying those benefits unless you have a reason to stop doing so prior to the hearing decision. Which leads me into my next topic here, weekly compensation. I talked about it briefly at the very start of the presentation. So there's three main types of benefits that you'll see: temporary and total, which is section 34, temporary and partial, which is section 35, as well as total and permanent, which is section 34A. So when can you stop paying those benefits? There's a few instances, according to the Massachusetts Workers' Comp statute, that allow you to do so. These are the only instances that allow you to do so. You cannot, if you're just not receiving medical documentation, unlike other states, the claim is not required here in Massachusetts to continuously supply that. So if you are paying benefits, you need to find a reason to legally terminate them. So there's a few. The first is fairly self-explanatory. If the court, whether it's an arbitrator, an administrative judge, or the reviewing board, or even a case where the decision's appealed up, if the court gives you permission, obviously you can do so. Fairly common to get a conference order or a hearing decision that would permit that. Aside from that, if the employee assents to shutting off compensation, then as long as they sign a written form, which is actually the form 107, for this particular instance, they would be required to sign that. You would file that with the DIA. And again, you can stop paying benefits at that time. Obviously, if the employee goes back to work, you don't owe benefits. Those benefits can be shut off immediately. You don't need to give 7 days notice or anything like that if they return to work. The fourth circumstance is actually quite useful, and I tend to see that a lot of insurers and adjusters don't fully take advantage of this. So if you have a written report, either from the claimant's treating physician or from an impartial physician, not an IME. IMEs do not help you in this regard. So if it's the treating physician or the impartial physician, and it says the employee is either capable of returning full duty or they can come back with certain restrictions, if you pair that with a written job offer from the employer, and when I say the employer, I mean the employer where the claimant was working at the time of the injury, not if they're hired elsewhere or seeking employment elsewhere. But if that original employer can put something in writing and extend a job offer to the claimant, and that's refused, you actually, as long as the language in the written job offer are precise and they cover everything, you can discontinue benefits at that time. There are a lot of nuances to the actual wording of the written job offer, so it would probably be recommended that you do have an attorney read that over before you send that out, just to make sure you're covering yourself. There are cases where the legality of a termination pursuant to this part of the statute is brought into court before a judge. So if you do elect to go this route, you want to make sure your defense is airtight. during the pay-out period, you have great leeway really to discontinue benefits for a lot of reasons. You can stop benefits if you give 7 days notice, if you have medical documentation from anyone, including an IME physician, that they're cleared to return to work. If you offer a job and the claimant refuses it, you can give 7 days notice and shut them off. Or if the claimant during the PWAP period isn't producing medical documentation, that's a valid justification for shutting benefits off at that point, again, with 7 days notice. There's a few more reasons as well. The Office of Educational and Vocational Rehab could give you permission to suspend or reduce benefits. I don't know about you, Jamie, I haven't had that happen too often, so it's fairly rare for that to apply.
Yeah, it's sort of few and far between, but it's a good idea to keep an eye out for those OEVR notices. A lot of times adjusters and attorneys will see them and kind of throw them away or ignore them because there's usually not a lot of impact with relationship to the litigation when you're looking at those OEVR notices. But that is one instance where once in a while it can really have a great impact on the indemnity benefits of the case.
Another reason actually is because benefits exhaust. So Section 34, you only owe those for 3 years, 156 weeks. So if you are paying benefits at conference and while you're waiting for the hearing, you've paid the full 3 years, you can actually stop paying benefits, and then you have a decision to make at that time whether you voluntarily commence Section 35 or Section 34A benefits. It's really a case-by-case basis. There's no right or wrong answer. But you do have the option to shut those off without the court's permission when they exhaust. Similarly, Section 35 benefits exhaust after 5 years, but if you've already paid 3 years of 34, they lose a year of the 35. So after 4 years of 35, they'd be shut off as well. Unfortunately, 34A benefits do not exhaust. So if you have a claimant that's, let's say, in their 30s, and they're awarded 34A benefits, you might be paying those for a very long time. So that's a case where you might want to explore alternative resolution because that's a great exposure that potentially you could limit if you move quickly on it. So aside from benefits exhausting, you can suspend benefits in a few other circumstances. So if you send a claimant a Form 126, which is an employee's earning report, basically it's a form asking them to indicate if they've received any earnings from any source within the past 26 weeks, so half a year, 6 months, and they do not send that back within 30 days, you can shut their benefits off and suspend them. But if they later produce that, you do need to turn the benefits back on and pay them retroactively. But it is a good tool if someone's been unresponsive and you're looking for a temporary solution that might move the case along. Also, likewise, if someone fails to attend an IME or the impartial exam, you can suspend benefits. There are certain rules that you need to follow when doing that. The code does talk about that, the CMR 452, or you can ask your attorney what precise language you need to use in the documentation that you sent to the court and to the claimant after suspending the benefits. If they miss the impartial exam, the claimant does have to pay a fine and reschedule that with the court. So it's more with IME that the insurer needs to take additional steps. If someone's incarcerated now, not charged with a crime, not arrested, not in jail overnight, if they are tried, convicted, and thrown into prison, they are not entitled to workers' compensation benefits, so you can shut those off. Unemployment benefits, you are not entitled to collect workers' compensation benefits and unemployment benefits at the same time. Expanding a little bit further on that, if you are only found partially disabled, an insurer or an employer can actually request that a claimant applies for unemployment at that stage, and there is an offset. But if someone's collecting unemployment and they're on 34, they're not entitled to the 34. Lastly, death. Someone's dead, you do not obviously have to pay them. You can shut them off. That doesn't happen too often, but a good way to stay on top of that is if you're sending out weekly checks to someone, they're not being cashed. you might want to look into that a little bit, because that could mean something's wrong or something happened. A little bit more difficult to do with direct deposit. But so the Form 106, this is a form that you file within the pay without prejudice period, as well as the Form 107, which is for outside of the pay without prejudice period. So whenever you modify or discontinue or suspend benefits, you have to file one of these two forms, unless you're shutting benefits off because you had an agreement, whether that be a Section 19 agreement or otherwise, or a decision or an order of the court. But in most circumstances, you are going to have to file a 106 or a 107, depending on how early in the proceeding you are. I mentioned this form a few times, the 108. So I did say earlier that there are two ways that litigation starts. One, when the employee files their claim, the 110. The second way is when the insurer or the employer, self-insurer, files a 108. What this form does, it tells the court that the insurer is looking to modify, discontinue benefits, or actually seek recoupment of benefits. So there are certain documents that you need to attach to that, whether it's medical evidence, whether it's surveillance reports, etc. There does need to be evidence supporting your requests, otherwise it won't get past the conciliation stage. So lastly, we do have a few investigative tools that, as attorneys, it makes our job a little easier, and we can justify bringing a case to a conference when we have these documents in front of us that support our defenses here. So IMEs, we've talked about a lot. They are useful, especially at the conference stage or for commencing litigation by filing the 108. If you don't have time for an IME, you can also have a records review done where someone will just take a look at what you have and offer an opinion that way. Record reviews are useful if either something's happened to the claimant and they're not available, or you're in a time crunch, you can go that route. With treatment notes, oftentimes everyone focuses on the diagnosis and the plan at the end. However, it is important to look at the subjective sections, because the claimants will often say something that they probably shouldn't in that section, and they are very useful tools. When a claimant says, I went to the gym 3 times last week and put up a 200-pound bench, which is my best ever, that's something you'd want to throw into a conference packet to support your position. You also want prior medical records. Your attorneys, when they subpoena stuff, they will typically, I like to go back 3 years, which helps with that 178 defense we talked about at the start of the presentation today. With respect to non-medical investigative tools, the 126, the form we talked about just a few minutes ago, the employee's earning report, that can be sent out once every 6 months, and I recommend that you do so. If not for anything, just to check on the claimant and make sure everything's still good with them. Labor market surveys, typically you don't do these until a hearing, but they are useful to have a vocational expert look at a claimant's educational history, their work history, and offer an opinion based on their current medical restrictions, whether or not they'd be able to make themselves marketable in the workforce.
And just to jump in, I tend to like these at conference for 34A hearings, just to better posture the case and to apply settlement pressure on an expensive case where the assertion is that somebody doesn't have a residual work capacity.
Yeah, they're very useful tools, especially like Jimmy said with the 34A. You don't want to take any chances with those, and you kind of want to throw everything you can if they're being brought at the conference. Social media, obviously, society now posts everything. So if you do have a private investigator that you like, ask them to do a social media search. You'll be surprised how many people leave their Facebook or Instagram profiles as public, and what they're willing to share, or where they're willing to tag themselves in places and the like. Statements, when the claim first, or the alleged industrial accident rather, first happens, it is useful to ask the claimant to file a written report. Those can be useful, especially if they start changing their story a little bit down the road. You can show that this is what you originally reported, and this is where you're going now. Also, coworkers, people talk. Coworker A might not agree that the claimant's filing a claim because they know that they really hurt themselves playing football 2 weeks ago. So it's not a bad idea to talk to a coworker and see if they know anything. And obviously witnesses and surveillance are useful tools too. Going to surveillance briefly, because we are running out of time here. When I have my adjusters assign surveillance, I do like to pick days where we know the claimant's going to be around. For example, if you have an IME scheduled on a particular day, it's not a bad idea to assign surveillance. You can track, the claimant's motions before and after. We tend to find that when someone's out of the house on that day, they might take the opportunity to do any other things after the IME while they're out. So we've caught people golfing, doing all sorts of things. I also suggest morning, afternoon, and night attempts. You don't know if someone's going to be working a Lyft or an Uber at night, so it's not a bad idea to check on that. And you can also look for those stickers on their car. A lot of times you can see those, and it's pretty apparent they're doing a little side gig. And lastly, weekends and weekdays, I like to split it up too. You're not sure if someone's working a landscaping job, maybe on the weekends, or doing work around their house. Saturdays and Sundays are great days to try to catch people doing yard work, especially during the winter too. After snowstorms, that's another opportunity to send someone out. But aside from that, Jamie, do you have anything else you want to add? I think we've pretty much ran up against our allotted time here, and it's really all we had.
Yeah, no, that's really it. I was able to answer a couple of questions in the chat box, but if you have any additional questions, our contact information is on this last slide here. So we'll leave it up for a minute to give you an opportunity to grab it, but we're always happy to answer questions. If this presentation created some questions for you, feel free to give us a call. We're always happy to try and help you work through issues, and we really appreciate your time. So thanks so much.
Yeah, thanks everyone. We hope you took something from this, whether it's small or large. And as I said earlier, if you're looking for a copy or a copy of the recording of this, please just reach out and we can definitely send that to you so you can use this as a tool, and hopefully it will provide some value to you.